Thank you, Mr. Chairman. My name is Dwight Duncan. I am professor of constitutional law at the University of Massachusetts School of Law in Dartmouth. I offer my testimony as someone thoroughly knowledgeable of the constitutional law governing abortion, but do not purport to represent my institution, obviously. Fearing the conceivable overturning of Roe versus Wade under the Trump presidency, the abortion industry and its legislative allies have once again, as they did last year, proposed a preemptive remedy in Rhode Island entitled the Reproductive Healthcare Act of 2018, H. 7340. Supposedly, this legislation replicates the central tenet of Roe versus Wade. The Act clearly states that the state shall not restrict an individual person from preventing, commencing, continuing, or terminating a pregnancy prior to fetal viability. But the central holding of Roe, as authoritatively interpreted by the U.S. Supreme Court in Planned Parenthood of Southeastern Pennsylvania versus Casey more than 25 years ago in 1992, was that prior to fetal viability, the state could place no undue burden or substantial obstacle on a woman's getting an abortion. This is significantly different from the proposed bills prohibiting any restriction whatsoever on a woman's terminating her pregnancy. The exceptions the proposed act makes are for Rhode Island law on care of babies born alive during abortions, written informed consent for abortions, parental consent for abortion for minors, the statutory protection for conscientious objection to abortion, and various insurance provisions. Why should this legislature want to codify Roe versus Wade to begin with? It is unquestionably the most controversial decision of the United States Supreme Court since the infamous Dred Scott decision that provoked the Civil War. And why should any protection for women via informed consent laws, or for minors via parental consent laws, or for conscientious objections to abortion, or for fetal life itself be only by way of exception rather than the general rule? The proposed bill shares the fetus counts for nothing view of the abortion industry. It institutes a laissez-faire policy with respect to the termination of human life. And why is this extreme legislation considered necessary? The fear that Roe versus Wade could conceivably be overturned by the U.S. Supreme Court. That premise is highly unlikely, even assuming Justice Neil Gorsuch, who has recently succeeded Justice Scalia on the Supreme Court, were ready to so rule. There are still a solid 5 votes in favor of reaffirming Roe, and therefore, at the very least, another Trump nominee who was solidly in favor of overturning Roe would be necessary. And even if Roe were overturned, the subject of abortion regulation would merely be returned to the state and local level where reasonable compromises could be enacted. Legislating abortion on demand now in Rhode Island would simply be preemptive overkill at the behest of the abortion industry. Thank you.